Good evening, everyone. How are you guys doing? We have some good
Evening.
news, or after whatever. We have some good news, and it's out of Texas, and it's in the Northern District of Texas, which is in Texas, of course, and it's a federal court. This is National Association for Gun Rights versus Garland, a case that is dealing with force reset triggers. And if you are familiar with the case, the government was told to go pound sand, and there was an injunction placed against the ATF on taking any enforcement action against the FRT 15 trigger, which is a force reset trigger produced by Rare Breed Triggers. And that was a very good ruling.
Wait, and they said you had to give them back and notify everybody that they're not illegal.
Yeah, within 30 days. The ATF tried to file for an administrative stay, a pending appeal on this, saying that that the judge's decision would be stayed until they have a chance to appeal. They have now been told to go pound sand, that there will be no stay. So the too long didn't read is that there will be no stay against the judge's ruling in the case, and we are going to go ahead and look over it. It is a 16-page decision, so it's not that long. So let's go ahead and bring it up, and I will also paste it out in the live chat, so anybody wants to bring it up, they can do that as well. So here we go. The National Association for Gun Rights, better known as NAGR, versus Garland. So let's just go ahead and jump into the order.
Before the court are defendants' motion to stay the judgment pending appeal, a brief in support filed August 1st, plaintiff's response and appendix filed, blah, 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 August 9, 2023. Having considered the motion and briefing and applicable law, the court finds the motion should be and is hereby denied. Junk slammed in door. The court also extends the deadline for compliance, that's what I was wondering about, with the affirmative obligations imposed on defendants by 6 months and must be met by February 22, 2025. So
yeah, basically what they were saying is that they had to return everything within 30 days. The ATF argued that that is impossible, and the judge is now giving them 6 months. But they wanted the whole entire rule stay because of that.
Wow. At this stage, the facts of this case are well known, and the court will not repeat them at length here. Because of this, the court only recounts background information necessary to understand the contextualized and pending motion. Plaintiffs comprise of both individuals and organizations. Plaintiffs Patrick Carey, Travis Spiegel, and James J.R. Wheeler are 3 individual citizens located in the Texas-Louisiana area. The individual plaintiffs individual plaintiffs has owned, currently owns, and or plans to own FRTs in the future. Plaintiffs also include two organizations, Nagger and Texas Gun Rights. Nagger and Tagger, with thousands of members in the Northern District of Texas, the organizational plaintiffs. On August 30th, 2023, the court granted temporary restraining order TRO to the individual plaintiffs, finding that the ATF expanded definition of machine gun is likely unlawful. The TRO enjoined defendants from implementing or enforcing any civil or criminal manner. The definition against the individual plaintiffs, the TRO, was narrow in scope, limiting temporary injunctive relief to the individual plaintiffs. Due to agreed extensions, the TRO remained in place through October 7th, 2023. On October 2, 2023, the court conducted an evidentiary hearing to determine whether the TRO should extend through the life of the case. Each party was permitted an expert witness to testify about the mechanics of FRTs. Notably, hearing made clear that there are no factual disputes regarding how FRTs work. Instead, the hearing confirmed that the parties' dispute enters entirely on legal question. Whether the FRTs qualify as machine guns under statutory definition, plaintiffs' expert testified that FRTs do not exhibit the attributes of a machine gun. Is that Rick Vasquez?
Yes.
Okay. As described by the statute, defendants' expert, on the other hand, testified that FRTs do not exhibit those attributes. This live testimony mirrored the positions these same experts proffered during a two-day hearing in the Eastern District of New York lawsuit. After hearing live testimony and reviewing the briefing, the court granted plaintiffs' motion for preliminary injunction on October 7th, 2023. Defendants appealed 30 days later pursuant to blah. Simultaneous to filing interlocutory appeal, defendants moved for a stay of the preliminary injunction pending the appeal to meet the defendants' request for, defendants' request for a ruling within 10 days. The court ordered expediting briefing, finding defendants failed to show that circumstances justified a stay or preliminary injunction. The court declined to do so. The next day, defendants asked Fifth Circuit Court to enter an emergency stay until such time that the panel could evaluate the merits of the preliminary injunction. The Fifth Circuit denied this request. Between the issuance of the preliminary injunction on October 7th, 2023, and the 5th, scrolling down,
The
Fifth
Fifth
Circuit
Circuit.
deciding not to stay relief on November 30th, 2023, the Supreme Court granted certiorari in Garland v. Cargill. The question for the Supreme Court in Cargill was whether a bump stock is a machine gun as defined by PLA. The same day plaintiffs sought summary judgment in case defendants similarly moved for summary judgment approximately 1 month later. Although briefing on the cross motions for summary judgment closed January 12, 2024, court waited to consider these motions until the Supreme Court's guidance in Cargill. Given that it would directly inform the merits of this case, the Supreme Court rendered a decision in Cargill on June 14th, my anniversary, 2024, affirming that the en banc Fifth Circuit Garland v. Cargill on July 23rd, 2024, the court granted plaintiffs' motion for summary judgment and denied defendants' cross motion for summary judgment. The court entered final judgment on July 2024. On August 1st, 2024, defendants sought a stay of relief awarded to plaintiffs. The motion is now ripe for the court's consideration following the filing of plaintiff's response and defendant's reply. Legal standard. While an appeal is pending from an interlocutory order that grants an injunction, the court may suspend an injunction on terms that secure the opposing party's rights, blah, bear a heavy burden, blah, scroll down. In determining whether to grant a stay of pending appeal, the court considers whether the stay applicant has made a strong showing that he is likely to succeed on the merits, whether the applicant will be irreparably injured absent a stay, whether an issuance of a stay will substantially injure other parties interested in the proceeding, where the public interest lies. Of these, the first two factors are the most critical. The party requesting the stay bears the burden showing that the circumstances justify an exercise of the court's discretion. A stay is not a matter of right, even if irreparable injury might otherwise result, but it is instead an exercise of judicial discretion, and that property issue is dependent upon circumstances of the particular case. A court must thoughtfully consider the factors, because a stay is an intrusion into an ordinary process of administration and judicial review, campaign for blah. Additionally, federal district courts possess the inherent power to control proceedings in their courts, while the exact boundaries of the district's court inherent power have not been explicitly delineated. The exercise of an inherent power must be a reasonable response to the problems and needs confronting the court's fair administration of justice. The power to stay any part of a case or even the entire proceeding is incidental to a court's power to dispose of cases to promote fair and efficient adjudication. Blah, the court discretion to manage the document. I don't know that anybody cares about all of this. Let's keep going. Analysis.
This is the good part.
Defendants respectfully, so defendants, the ATF, respectfully request that the court enter a stay pending appeal, or at minimum stay those aspects of the final judgment that impose affirmative obligations on the ATF to return certain FRT devices to an individual, remedial notices, and extend injunctive relief to unidentified individuals and entities. The court considers the motion in two parts, beginning with whether to stay the entire final judgment and turning to the implicit question of whether to amend the deadline to comply with the affirmative obligations. Applying the four well-established factors here and considering the arguments raised by the parties, the court determines that defendants have not met their burden to show the court should exercise judicial discretion to stay the entire final judgment pending appeal in this particular case.
All right,
That's it.
we're going to skip a lot of this, not a lot of it, but just but it does say that they do have extra time to return them just because of the amount that they have, and they have 6 months to return them all. And trust me, they're going to take all 6 months.
And that's how that happens.
Okay, let's look at the success on the merits of the case, because this is interesting.
The court must first consider whether the defendants have made a strong showing that they are likely to succeed on the merits. They have not. The defendants disagree with the court's ultimate ruling at the summary judgment stage that the FRTs are not machine guns. Defendants' arguments have been rejected on numerous occasions by the court. The only notable change in the defendant's argument is the Supreme Court's decision in Cargill, which was addressed and rejected in order with defendants now take issue. The first defendants argue that because of the Supreme Court's ruling, Garland v. Cargill, an appellate court is likely to render a different outcome than the decision reached by this court. In support, defendants argue Cargill defines a trigger in such a way to include FRTs. Plaintiffs argue Cargill demonstrates it is the physical movement of the trigger that matters, not the movement of the trigger finger or pull of the trigger. After considering defendants' argument and having already considered this aspect of Cargill at the summary judgment stage, the court agrees with plaintiffs. Yes, both versions of Cargill support the conclusion that the ATF's classification decision cannot stand Indeed, the record in this case is clear. FRTs do not fire multiple rounds with a single function of the trigger and thus do not qualify as machine guns. Door slam here. Click. The court previously determined that plaintiffs succeed on the merits in light of the Supreme Court's opinion in Cargill. Defendants' reading of the case does not compel a different conclusion. There are no new arguments or authorities in Supreme Court's decision in Cargill. Accordingly, court finds that defendants who bear the burden to show a stay pending appeal is warranted fail to meet their burden here, let alone produce the strong showing required for such extraordinary relief as a stay pending appeal. Therefore, this factor weighs heavily against granting the stay. 2. Irreparable harm. Regarding the second stay factor, the court concludes that the defendants have not shown that they will suffer irreparable harm, absent a
All
stay
right, maybe we
pending
can get
appeal.
that. In order to get a appeal, they would have to prove that there is
Well,
irreparable harm.
there's no harm to the ATF or public at large.
And this, but there is one line I want you to read here. There was a little bit of a hubbub whether the WOT triggers are included in
Yes.
in right here. Read
Finally,
this.
defendants argue that the court's order will make it nearly impossible to recover FRT 15s and WOTs acquired while the order is in effect if the ATF prevails in this litigation, but this conveniently ignores that nearly all of the injunctive relief with which defendants contest is identical to the other relief that has been effective for over 10 months. And importantly, the Fifth Circuit declined to stay this same injunctive relief law. In fact, Fifth Circuit rejected these same arguments. Defendants argue that they will suffer irreparable harm because the injunction will make it harder for them to seize FRTs, but this assumes wrongly, in our review, that FRTs are illegal. Accordingly,
so basically that clears it up right there. So all FRTs are illegal.
So FRTs, WOTs, what about the Hoffman super safety?
According to this, it's a FRT. It works by using it's a force reset trigger. So I do not believe that that because of this ruling, I do not believe the ATF can prosecute that. Now, what does this have to say for the people that were arrested for producing them?
Twin Bros.
Twin Bros, yeah, I'm pretty sure their attorneys are aware of this, and if their attorneys aren't, they should be.
Right. So where are we reading? Balance of equities?
Well, okay, balance of equities just it basically says we can go through a little bit of it.
The court also finds that the remaining two factors, comparative balance of the equities in public interest, once again do not justify a stay in pending appeal. The court previously balanced the competing interests at issue in this case and reaffirms that conclusion. Defendants failed to shift equities in their favor. The court addresses the public interest factor. Defendants reassert many arguments the court has considered in previous motions. In other words, they're saying the same crap over again. These arguments, once again, do not tip the public interest factors in their favor. Defendants concentrate on the potential harm the public will face absent a stay. For instance, defendants state the ATF has encountered these devices in numerous criminal settings, but this is not a casual argument, nor is it evidence that FRTs are uniquely dangerous or more likely involved in criminal activity than other firearm or firearm accessory. Defendants state they cannot provide the specifics due to the illicit nature of the market, yet maintain the number of unlawfully manufactured, imported, and distributed FRT machine guns likely exceed the number of lawfully manufactured and imported machine guns. It is not at all clear what extra criminal activity is caused by an FRT as opposed to other illegally possessed firearms. And it is similarly unclear how an FRT added to danger of these situations, particularly after the court's ruling that FRTs are not machine guns. Thus, just like the TRO and preliminary injunction stages, defendants provide no specific casual arguments explaining how the public would be harmed by an injunction. The casual deficiencies become even more apparent given the defendant's previous admission that their criminal enforcement proceedings pertaining to FR-15s and WOTs mainly targeted those individuals charged with multiple other gun-related felonies, as observed with granting the preliminary injunction. If only the targets of defendants' enforcement actions are against those who violate other gun laws, then the prohibition on FRTs does nothing to protect the public.
Yeah,
Defendants,
basically, every charge of someone with an FRT was an add-on charge besides the twin bro stuff, but we'll see how that turns out. But that's what
gotcha.
they're just saying.
Def- Defendants' new argument that FRTs appear like normal triggers in both speculative and relies on negligence of officers handling the weapons. This is not sufficient to establish FRTs unique threats to public safety, let alone the possession or transfer of FRTs by plaintiffs, who by definition in this case are not prohibited persons and do not pose a public, I'm assuming, threat. Scroll down. Safety threat. Such a general public safety concern simply cannot serve as justification for enforcement of an illegal interpretation of a criminal statute. There remains no evidence to suggest that FRTs in the hands of law-abiding citizens will disserve the public interest. Even after Cargill, defendants continue to point out to the rate of fire being similar to machine guns, but this fact is irrelevant to any consideration of the potential harm FRTs pose. That is because the statutory definition of a machine gun, as emphasized by both versions of Cargill, does not define a machine gun based on this attribute. Let's see, Congress did not use the words describing the shooter's perspective of the weapon's rate of fire. Instead, it made up an entirely new phrase by single function of the trigger that specifically pertains to the mechanics of a firearm. Congress did not write a statutory definition of machine gun keyed on when a firing sequence begins and ends. Section blah asks only whether a weapon fires more than one shot by a single function of the trigger. Until Congress changes statutory definition, any contentions regarding rate of fire have no bearing on the court's analysis. Wow. For better or worse, the statutory definition of machine gun does not presently include rate of fire as an attribute of machine guns, despite
Despite the claim that it cannot be disputed, FRTs are extremely dangerous. This claim does have any bearing on the analysis. I think you meant to say doesn't have any basis,
yeah.
but whatever. Keep on going.
Defendants argue that potential confusion can occur from remedial mail notices. Again, this fundamentally tied to the merits. If, as this court has ruled, FRTs are not machine guns, then informing people about ATF's erroneous rule is not irreparable harm, but an affirmative good to inform the public who has already received false information. In contrast, plaintiffs would be substantially injured by a stay. The court has already found twice in slightly different contexts that plaintiffs face a substantial risk of irreparable harm if defendants are not enjoined from engaging in enforcement activities. Not only do plaintiffs face credible threat of prosecution, including when used coercively to confiscate property without filing charges, they also face the loss and use enjoyment of their property as a result of the defendant's renewed retrieval efforts. Given plaintiffs' actual success on the merits, a stay would only undermine and even threaten the vindication of their rights.
Remember, the ATF was going around forcing people to hand over. They're going like door to door, basically, to force people to hand over their FRTs. But the government would never go door to door to get something, right?
Right. They would never do that. They're never coming for your guns.
No.
As before, defendant Sky is falling argument do not overcome the serious harms plaintiffs face. Defendants' arguments are premised entirely on the presumption that FRTs are machine guns, a conclusion rejected by the court on 3 separate occasions. Defendants continue to offer speculative, conclusionary statements about supposed danger of FRTs that are not supported by their own facts. And the realities discussed above cast doubts on the parade of horribles that defendants say will occur if the final judgment remains in effect pending appeal. Defendants do not carry their burden to show how equities now weigh in their favor, nor do defendants show how the public interest will be served by a stay pending appeal to contrary vacatur of ATF's classification decision, along with accompanying declaratory and injunctive relief, collectively reestablish the status quo of non-enforcement against law-abiding citizens and serves the public's interest by preventing defendants from enforcing their unlawful definition of machine gun. For these reasons, the final 2 factors also weigh against the stay.
Affirmative obligations.
Unlike earlier relief awarded to plaintiffs, the court's final judgment ordered the ATF to comply with 2 affirmative obligations to return to all parties, including manufacturers, distributors, resellers, and individuals, all FRTs and FRT components confiscated or seized pursuant to their unlawful classification within 30 days of decision, and to mail remedial notices correcting their prior mailing campaign, and warned suspect FRT owners that possession of FRTs and FRT components was purportedly illegal. For the same reasons discussed above, defendants do not carry the burden of the court to exercise judicial discretion to stay the final judgment pending appeal in the particular case law. Nonetheless, defendants have identified a number of practical considerations as it relates to the timeline to comply with the affirmative obligations. First, ATF does not know the identities of organizational plaintiffs' claimed members, let alone which of those members is entitled to return of their FRT devices. Additionally, plaintiffs are unaware of some members who are eligible to the return of their FRTs. Defendants also contend that returning all FRTs covered by the order within 30 days would still not be feasible. According to defendants, the ATF would have to locate devices among approximately 12,000 FRT-15s and WOTs in its possession, which may be held at different points around the country, and it would also have to determine whether the owners are otherwise prohibited persons who cannot legally own a firearm before having to contact owners and arrange for return. In sum, the ATF claims it is not able to comply with the court's order within 30 days, in other words, August 22nd. These points are well taken. Pursuant to inherent power in federal courts to control proceedings, the court determines that an extension, not a stay, is appropriate for relief. Such an extension is, in this case, reasonable response to the problems and needs case law, thus with a view toward the fair administration of justice in this case and effectively vindicate full rights of the parties who succeed on the merits. The court will adjust compliance deadline. The practical issues complying with the court's final judgment is sufficient reason the court, in an exercise of its inherent powers to modify the deadline of the return of, it says FTRs, but it meant FRTs, in final judgment, except as it applies to the individual plaintiffs or members of the organizational plaintiffs who specifically request their FRT devices and provide sufficient documentation to the ATF. Affirmative notices from plaintiffs obviates the administratability concerns articulated by the defendants. So in other words, I got to contact the ATF, say, hey, you took mine. I'm a member of GOA, NAGO, or whatever, and then they can send it back to me. Is that what they're saying?
Yeah, well, you just got to connect them and say, I want my back. But yeah, so go ahead.
For the foregoing reasons, the court denies defendants' motion to stay judgment pending appeal. The court grants defendants an additional 6 months to comply with the affirmative obligation, which shall be, in all bold caps, completed by February 22nd, 2025. This extension does not apply to individual plaintiffs or members of the organizational plaintiffs who specifically request return of their FRT devices and provide sufficient documentation to the ATF. ATF shall return those devices as soon as practicable following the specific request. So ordered.
If you're an organization member of NAGR, you get yours back. They don't have the extension, but for everyone else, they got an extension. And this was signed by one of my favorite judges, Reed O'Connor, who also did the frames and also in Vanderstock and also ruled on pistol braces as well. So there you go.
Go Reed. Go Reed. So here's an interesting thing.
Kurt 24, congratulations on the new job. I want to say that.
Yeah. Congrats, Kurt.
And thank you for being a member. Joe Morgan, I hope you get back on your feet. I hope you get everything worked out.
Oh, man. Oh, that's rough.
All right.
God bless you, man.
Yeah. So basically, this is good. The ATF got their PP smacked again. They tried to get a stay. The judge said absolutely not. But they did get an extension, which I figured that they were going to get. Because
they've got 2 days to get back all the NAGR members, FRTs and WOTs.
Well, yeah, they have to get it back as soon as possible.
Okay. So I got a couple of commentaries on this. So first commentary is pertaining to, like, if I am the ATF and I don't get everything done by February 22nd, what's the penalty?
They can be held in contempt of court.
Which means what?
They could technically they could jail.
They could jail Merrick Garland?
Yeah. I don't think that they would, but Reed O'Connor could.
And again, I don't mean to be a dick about this, but unfortunately, one of my favorite vice presidents ever said there's no controlling legal authority, and which, as Congress interprets things, when there's rules upon people in Congress, that if there's no penalty associated, really it's just a guideline. And if anybody knows who said there's no controlling legal authority, and you enter that name, enter the name in the chat, I'll send you some swag. So
I shouldn't answer it.
So you shouldn't answer that.
Okay.
The other thing is, while the ATF is, making up rules in their Chevron deference way,
can I get
no.
Okay.
In their Chevron deference way, if nobody gets it, we could give hints. They're like, well, what is the surface area of a brace to be so it complies? So like, well, we can't tell you that because then you would, work around it. It's like, oh, so I'm guilty of a crime, but there's no specification of what the crime is to be guilty of.
What does that have to do with force reset triggers?
So what it has to do with force reset triggers is the ATF is put on the other side of this. It's like, the Reed O'Connor saying return them. They're like, but we're not sure how to return them. It's like, return them, damn it.
If they had enough information
to take them,
we got a winner.
Woo! Winner, winner, chicken dinner. Send me a message on Instagrams. Flying Rich _official, and I'll send you some swag from this weekend.
Oh, Al Gore, FF Michael, firefighter Michael. You were the first one.
Yeah, Al Gore was caught making campaign finance calls from his political office,
Yeah,
which
that's
is illegal.
yeah.
And when
But
questioned
we're not
upon
talking
that,
about Al Gore. We're talking about force reset triggers.
okay,
Stay on topic.
so
Yeah. Okay. So
uh,
basically, what I think the ATF was able to was able to find all these people to go door to door to collect them. They should be able to return them just as fast. And it took them
yes.
6 months to go around and collect them all.
All right. So, one further question? I know they wheeled hand trucks full of WOTs out of 3 locations at Big Daddy Unlimited. Being that Big Daddy Unlimited does not exist as we know it, what do they do with those?
Well, I think if I could be mistaken, but I think I remember in the patent lawsuit that they would have to be returned to rare breed.
Oh, right. Yes, good point. Good point.
Yep. Oh,
Safety Harbor. So Walt says they can return them the same way they took them, in person.
I know who FF Michael is, so I'll hook you up.
Okay, good.
I just got a text. I'm not sure if he wants me to say who he is, but he is kind of a big deal in the
Oh
gun.
yeah, cool.
Yeah. Yeah. And, he's a gun rights advocate. Let's just put it that way.
So let's just say in summary here, the ATF didn't like the its temporary restraining order, TRO.
No, this is a permanent, like an injunction.
Oh, an injunction. So the
Yeah,
ATF didn't
you
like
can
the
buy them
injunction. So the case is still going to court, but until
in
then,
Florida. FRTs
what do you
are.
say in Florida?
One car fast wanted to know about the AUG FRT update. I said Rich is in Florida and he's not allowed to install an enhanced trigger under Florida law.
Correct. And again, that's another case that hasn't been proved or tested. But
Yeah, it might be
um,
another. It might be an SSL off too. I don't know. I have to read up. Right. I thought they had to turn over any offending products to Rare Breed, but I could be mistaken on that.
gotcha. So very cool, very cool. And so going through the history of this case, the um, the case has not hit court yet, but NAGR has gotten a permanent injunction against this rule. So basically, it's kind of like the
It
pre-case.
no. It hasn't hit the circuit court yet. The district court's done. They
Okay,
got
so the district court.
motion
So it's
for
awaiting
summary
an
judgment
appeal. Okay.
in the district court. Yeah.
And
So
so the ATF was saying, hey, while it's waiting appeal, can we just
yeah,
enforce the rule?
yeah. They asked Judge Reed O'Connor to stay his own decision. What I think that they're going to do now is they're going to go to the circuit court and ask the circuit court to stay the decision until it can be heard. I don't think they're going to be successful with that.
So there's a couple of reasons. One, Chevron, the basically government got their junk slammed in the door
Well,
on
Chevron
Chevron.
doesn't exist anymore. Yeah,
Right.
Chevron's gone.
So basically the ATF can't make up new rules which work as law without law. They can't do that. They can't say, oh, we're redefining what a machine gun is. No, there's a law about that. You can't do that. And so that's Chevron, that's out the door. And then the bump stock decision also weighs heavy in this case. It's like, really? Yeah, that's not a machine gun either.
Yeah. Brennan says, I think the super safety is mechanically different enough that it will require its own litigation because the ATF will not act in good faith. And I 100% agree with you. That's why I
Right.
said it's up to the safe, the Twin Bros
Mm-hmm.
lawyers
Mm-hmm.
to do that. Direct D says, let me know when the Second Amendment actually means something. I got a felony over
Ooh.
10 years ago and I don't have a right to defend myself. The Second Amendment is a privilege, not a right. The Second Amendment is a restraint on the government. The government has
Right.
been overlooking that. If you
Yeah.
are a felon and once you serve your time and once you get out, you should have all rights restored, including your gun rights. And hopefully one day that will be the case.
In my opinion on that is like, hey, if you're a danger to society, you should be in jail. If you're not in jail, you're a citizen and you should have all your damn rights.
You served your time, you did whatever, you're out now. You should have your rights back.
Yes.
And you shouldn't have to go through some damn process of trying to get your restoration of rights. It should be automatic. Once you walk out of that prison, you should have all rights back.
So I don't know if you're familiar with DLD After Dark, but Dark phrases it in a certain way that when you're in jail, prison, you're separated from your property, and when you're released from prison, you're reunited with your property and your rights.
Yeah,
And
that's
that's how I.
but the Twin Bros thing, I think they're gonna make Twin Bros fight this, even though
Of
that.
course they will.
But yeah, but
But
we'll
this is I always talk about the ATF. It's kind of like motor vehicle hates cars. How would you have a Department of Motor Vehicle that hates cars and makes things difficult for you? Whereas the ATF should just make sure everybody is doing the right thing, but
ATF
in
shouldn't exist.
ATF shouldn't exist. Amen.
That mean full stop there. ATF should not
Yeah,
exist. Full stop. There's no reason for the ATF to exist. Abolish
correct.
the ATF, as my kids would say.
Ooh, and that's what my shirt says. Save a pup, abolish the ATF.
Yeah. My kid has a mouse pad on his desk. My 11-year-old has a mouse pad on his desk that says abolish the ATF. My 7-year-old has a stuffed puppy that says save a pup, abolish the ATF. Well,
So
Big
can
Daddy
we address?
High Caliber Firearms is their new company name, but it's a different company, but owned by the same people. So technically, they're not allowed to take anything because everything else is being liquidated. Whether they do or not, who knows? We'll have to see. I would not be surprised if they try to do something sneaky, but yeah, companies do stuff sneaky all the time. Yeah,
Yep.
pretty much. Heavy duty, no, VSO Gun Channel. He did a good video on the whole entire thing where he broke everything up and did. So
It's
if you
funny. I
want
watched
to,
that this morning.
yeah, if you want to watch about what's going on with BDU, I heavily recommend the VSO Gun Channels, a breakdown of it. It's really good. But yeah, that is it. This is another victory for us. We keep on winning. They're winning.
Oh no.
You're gonna be winning so much. You're gonna be tired of winning.
Right. Right.
We're winning
You're
the ATF.
channeling Donald Trump. What's that mean, Crumpy?
Nothing. Absolutely nothing. I'm voting against Kamala by voting for Trump. If that makes any sense. But yeah,
Oh, Night Strike. What up?
ran into one of your buddies there. I just want to say that it was good meeting everyone that made it out to goals this weekend. I met a
Yes.
lot of people. I had to sign autographs, which was weird.
Really? Cool.
Yeah, I signed like 8 shirts, which was unusual.
Wow, I should have walked around with you. I would have gotten recognized.
I was meeting with a lot of different people. When I go to stuff like that, I wish I could have fun, but it's more of meeting.
Yeah,
Got
it's funny. I kind of recapped in my brain. I'm like, I barely saw Dark. I barely saw Crump. I roomed with Chris from the 740, and I barely saw him.
yeah.
Walter Keller and I walked around a lot together, but we squirreled and went different directions a lot.
No, I mean, yeah, I had meetings. Like I met with Pete Brownell, which was kind of cool.
Oh, cool. Pete's a good guy. I like him.
Went out to dinner with uh, the Lieutenant Governor of North Carolina, Mark Robinson. Just had a lot of meetings and stuff like that. Got a new sponsor coming in.
Oh, cool. So we are doing the Turkesterone. Good to know.
And no, it's not testosterone, but Rich is the producer, so there you go. But yeah, but we're gonna do a full recap at 5 o'clock on John Crump Live. If we wants to tune in, we'll have that done. Yeah, so we're just gonna recap goals.
Yay! And we're gonna have Luis
Yeah, I
on the
hope so.
show.
I gotta verify it one more time just to make sure.
Oh yeah. Okie doke.
Yeah,
Cool.
yeah. And also I'm working on a couple of pretty goddamn big stories.
Woohoo!
Like big stories.
Sweet.
Gotta make some waves, guys. But I've been doing a lot of research on that. But yep, with that, I think we're gonna get out of here. Thank you very much for watching, and another good win, another good day. See ya.
Amen.